This is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Ms. Brady, Mr. King, Ms. Nelson, Ms. Hicks, and Ms. Spengler. And the prosecution is represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Mr. Edson, and Ms. Tish McGuire. We are outside the presence of the jury. There are some things I need to talk to you about outside the presence of the jury. So let me do that now. First, I want to make a record that I inadvertently numbered two juror question forms as juror question form number 160. The last question form that was used yesterday should have been number 161, and so I've changed it from 160 to 161, but I think that when I read the question here at the bench conference on the record, I said 160. And so I changed it to 161. The second thing is that I inadvertently skipped over number 154 in the juror question forms. And so I have dealt with it the same way we dealt with number 8, which was also inadvertently skipped. I filled out a blank form that simply indicated there is no juror question form number 154. That number was inadvertently skipped. The third thing on my list is that yesterday there was an objection to exhibit number P-TR-1076. That was the document from Match.com, was it not?
It was, Your Honor.
And we had a bench conference with Ms. Brady and Mr. Edson, and I ruled that part of that exhibit should be redacted, and specifically, it was the category that asked about the defendant's religion and his response that he was agnostic. And so that was redacted pursuant to my instruction. But we had a conversation at the bench about whether I had ruled on that issue in a separate order or I had addressed that issue separately, and neither counsel could remember. I seemed to remember that I had addressed something related to religion, but I couldn't remember what specific order it was, and I wasn't sure exactly what the specific ruling was with respect to that issue. And so I went back last night and looked at it, and there were two orders that I issued that are related to it. One is order D-248, and the other one is order D-264, small a-3. And the one that is more specific to it is order D-264, small a-3. Both of these orders dealt with Dr. Reed's interview of the defendant, and I don't think that my ruling yesterday is inconsistent with my rulings in those orders, and so I'm going to stand by my ruling yesterday that required the prosecution to redact that small portion from the document that was produced by the document which is P-TR-1076, which was produced by Match.com. The discussion in orders D-264 small a-3 and D-248 had to do with religion in part, but there was nothing related to the defendant declaring that he was agnostic. I think that there were some statements in the videotaped interview by Dr. Reed related to religion, related to faith, related to spirituality, but nothing where he declared that he was agnostic. And so I think in an abundance of caution, I'm going to stand by the ruling I made yesterday requiring the redaction of the category religion and the profile, and also the statement agnostic. The next thing I wanted to talk to you about is Dr. Reed. I understand that Dr. Reed may be testifying today, and I just want to make sure that everyone remembers all of my rulings that I have made in this case. I know I've made a lot of rulings. Mr. Brockler yesterday indicated that the prosecution is intending to play the videotaped interview of the defendant by Dr. Reed. Is that right, Mr. Brockler?
Yes, Your Honor.
Okay. And I ordered that some portions of that be redacted. And I'm assuming that the redactions have been made and that the defense has checked those redactions, and that whatever is going to be played is going to be the redacted version of the interview. Is that correct?
My understanding.
Okay, great. And I've said before, opposing counsel is responsible for checking that all redactions are made. So, Mr. King, I'm assuming that's taken place.
Judge, we have been provided with the redacted copies. We've checked them against the court order, and we believe that they comport with the court's order.
All right.
I also wanted to confirm, however, that in addition to that issue, that Dr. Reed has been instructed pursuant to the orders that the court has just noted, 248, 264A, I think 246 is also included, and D250 were the orders that I have that would relate to Dr. Reed's testimony. And I wanted to make sure that he had been instructed pursuant to those orders, because I have not done it, because I'm not calling him as a witness.
That was next on my list. Specifically, I ruled in Order D246 that he cannot say what he said in his report, which is that the defendant had a particular mental state at the time of the shooting. What I said he can testify about is consistent with Colorado law and the definition of insanity, whether he was capable of forming the mental state, but not that whether he actually had the mental state. And I'm just paraphrasing, but you all have my orders, and so he needs to be aware of all the orders that I have issued. Those orders that I have are D246 small a-3, D248, D246. I didn't have D250 in my list, but that may well be another order that I issued related to that. So, Mr.
It
King,
is, I think, Your Honor.
all right, and so D250. And so please make sure that he understands what limits there are and that he complies with all my orders. And then counsel also must be careful in questioning him to make sure that you don't go beyond any area that I have prohibited.
Yes, sir.
Okay. And by the way, to the extent that you're intending to introduce Dr. Reed's report, I indicated that it would have to be redacted consistent with my orders. So I don't know whether that's something the prosecution is intending to do, but to the extent that you are, the report should be redacted in accordance with all my orders. All right, last thing, actually two more things on my list. There's one juror who wishes to speak to us this morning. I think it's juror number 737. 706, sorry. It's juror number 706. So we'll bring her in just a moment. Before I do that, though, I have one other item on my list. Yesterday, there were two objections to a question about whether the defendant ever appeared to be detached from reality. that's a question that initially was asked by the jury, and then it has been asked after that by the prosecution of multiple witnesses. There has been no objection by the defense to the question when the prosecution has asked it of multiple witnesses, and then yesterday it was objected to a couple of times. And I overruled the objection because I understand the question to be referring to observations related to the defendant's behavior and demeanor. But given the objection and given the basis of the objection, which was that it calls for speculation and that it is in violation of Rule 702, which governs expert testimony, I believe that it was Rule 702. It got me thinking about it, and I am a little concerned that some of the jurors may misinterpret that question and the answers to that question. They may view it differently than how I'm viewing it. I viewed it and I have allowed it because, let me back up. I have allowed it because I viewed the question to be inquiring about observations, not because I viewed the question as inquiring about opinions or comments on the defendant's sanity. But I wonder if some of the jurors could take it the wrong way or could draw the wrong inference from it. Colorado law allows the prosecution and the defense to introduce evidence, lay opinion evidence about the defendant's sanity, but there's a certain foundation that has to be established. In this case, the prosecution, I don't believe, has intended to introduce these answers as opinions on the issue of sanity, as lay opinions on the issue of sanity. I think the prosecution's intent was to get after the observations of the witnesses related to the defendant's behavior and demeanor. That's how I understood it. But given that a juror may read it differently or may infer something different from it, I'm wondering whether a cautionary instruction related to those questions and responses is appropriate. I drafted one and I'll read it to you, and then I'll ask you for your thoughts. Here's the question, or here's the proposed instruction, excuse me. Members of the jury, some witnesses who have testified have been asked whether the defendant ever appeared to be detached from reality. You should not interpret the responses to this question as opinions or comments on the defendant's sanity. Rather, the responses to this question should only be understood as conveying the witness's observations about the defendant's demeanor or behavior. You should not consider these responses for any other purpose. And remember that it is up to you to determine how much weight, if any, to give to these responses. And then what I would propose, given that I have now thought more about this and it has caused me to be a little concerned about it, I would ask that the question not be asked in that fashion anymore, but that I would propose giving this instruction in terms of the times that it's been asked in the past. Do the people have a position on this? Mr. Brockler, why don't you go to the podium, please?
As to the court's proposed, you're right, this is awkward.
Okay.
As to the court's proposed cautionary instruction to the jury, I don't have any objection to that. As to the court's request that the question not be asked in that form in the future, there are a couple witnesses that we at this point intend to call who come from that same batch and had other observations. Is there a form of that question that the court would find less concerning? And I feel like what the court described as the intent of the prosecution has been, and that is to ask people that had an observation to observe him if those observations were such that he appeared to them to be detached from reality. So, Your Honor, I don't want to abandon what I'm trying to get at with their observations, but I do not want to do anything that prejudices the defendant in the case.
I think you can ask more specific questions about their observations of the defendant's conduct and demeanor. Was there any time when you observed him do something outlandish or something out of the ordinary? Or was there any time when he said something that didn't make sense to you or that was unusual or that was out of the ordinary or things to that effect? I think those questions are safer because I think those are going specifically to observations as opposed to having someone say, did he appear to be detached from reality. I'm concerned that that question could allow a juror to infer that this goes to the defendant's sanity, or that it goes to delusions, or that it goes to whether someone is just not in touch with reality in the psychological sense, in the technical sense that only an expert would be able to talk about. And that's what I'm trying to avoid. But I think you can ask questions that are more specific, that go to the specific behaviors, specific demeanor, that kind of thing. I think witnesses are allowed to talk about what observations they made. I just think we should avoid that question, because now that there has been an objection and I've thought more about it, I'm concerned, a little concerned, that someone might interpret it differently, someone on the jury might interpret it differently than I am and than you've intended it.
Yes, sir.
All right. Anything on the defense's behalf? Mr. King, what's your position?
Judge, we'd ask that the cautionary instruction be given, and we have no objection to the instruction as the court read it.
All right, great. Thank you. I will give it. The last thing on my list is Juror 706, who wants to talk to us. But before I bring her in, is there anything that the parties want to talk about? Mr. Edson?
Very briefly, Judge, going back to People's Exhibit 1076, the Match.com records.
Yes.
We have made 24 copies for publication to the jury pursuant to the request made yesterday. I have assured that I went through all of them, and the redactions that were ordered by the court have been made. I actually showed Ms. Brady a copy of it yesterday and submitted it as the original exhibit, and made the other one a court exhibit. So we're probably going to ask that be published before we get to the next break, so I wanted to tell the court now that the 24 copies are redacted copies.
All right, thank you. Mr. King?
Judge, I have one more thing, and then Ms. Spangler has one brief thing. The court brought up Dr. Reed's report, and I just wanted to put on the record that if, in fact, the prosecution is intending or does in the future intend to introduce the report, we would have a general objection to that, and we would ask to be heard on that issue.
I will give you an opportunity to be heard on that if the prosecution moves the admission of the report. And we'll do it outside the presence of the jury, of course. All right, Ms. Spengler, do you have something?
I do, Your Honor. The court mentioned giving an instruction to the jury regarding the correction to the demonstrative exhibit, and I have a proposed instruction for the court to take a look at.
Have you shown it to the prosecution?
I'll hand a copy to the prosecution.
All right, please.
I'm going to mark it as defense tendered instruction 1.
Okay,
If I may approach, Your Honor.
yes. Thank you.
Your Honor, I'm going to need some time to take a look at this. There's quotations in it which I'm assuming are from precedent, and I want to check to see if it is correct.
All right. I don't have a concern with the first paragraph. The second paragraph, I'm going to give the people an opportunity to respond, and it may depend on what the prosecution intend to do with that model anyway. So I'll give you time to think about it, and then we'll proceed. Don't let me forget about it, though, please. All right? We'll table that one for discussion. All right, let's bring in juror number 706, please. Okay. Good morning. The record should reflect that juror number 706 is now present in the courtroom. Good morning. How are you?
I'm fine.
Good. I understand you wanted to talk to me about something private, and I want you to know that we're in a public courtroom and there are people in the gallery, as you can see, and also, as you know, this is being broadcast. I mean, that there is access to the feed. And so are you, when you say that you wanted to talk to me about something private, did you mean you wanted to talk to me about something outside the presence of the rest of the jury, or did you mean something of a private nature?
Private nature.
Okay. All right. And so are you comfortable discussing this in open court, or would you,
I suppose because it's something that we've all had.
okay. Well, it's up to you. If you're comfortable discussing it in open
Okay.
court, I'm okay with it, and we'll proceed. If you're not, then you tell me, okay?
Okay, I'll tell you.
Okay?
I've had diarrhea since 2 o'clock this morning, and in the time the hour that I was getting ready, I was went to the bathroom 4 times, but it's getting better. And I thought, well, I could tough it out, but I did want you to know I may have to take a break in between our breaks, just in case I get very uncomfortable and don't think I can do it.
All right. You're
If I-
absolutely right. This is something that has happened to everyone. So this isn't unique to you, and I'm glad you brought it to my attention. And whenever you need a break, you just need to get the attention of my staff or me, and then we'll take a break immediately whenever you raise your hand, okay?
Okay.
Is that good?
I would appreciate that. If I can just raise my hand, I'll be fine.
Absolutely, and I will
Okay.
instruct my staff to keep an eye on you, because sometimes if I'm paying attention to the witness, I may not catch you raising your hand, but my staff will, and they will let me know immediately.
Thank you very much,
You're
Your Honor.
welcome, absolutely, and you should not be concerned at all with this, and as you said, it's something that we all go through, so thank you. Okay, the record should reflect that juror number 706 has now exited the courtroom. Are the parties ready for the jury, Mr. Bruckler? Yes? Mr. King? Yes?
Yes, Your Honor, may I approach your staff? I think we need a battery replacement for the microphone.
Oh, yes. They didn't do that on purpose, Mr. King. Do we have batteries? We'll change the batteries, and then we'll have you test it, make sure that it works.
I do have the Ricky Martin suit on, Judge, so.
Well, maybe then it was intentional. It's working? Okay. All right. Ms. Agel tells me it's working, so. Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury has joined us again. Good morning, everyone. Welcome back. Before we start, I have an instruction that I need to give you. The instruction is as follows. Members of the jury, some witnesses who have testified have been asked whether the defendant ever appeared to be detached from reality. You should not interpret the responses to this question as opinions or comments on the defendant's sanity. Rather, the responses to this question should only be understood as conveying the witness's observations about the defendant's demeanor or behavior. You should not consider these responses for any other purpose. And remember that it is up to you to determine how much weight, if any, to give to these responses. Does everybody understand that instruction? Yes. All right, everybody's saying yes, and everybody's nodding their head yes. Great. The second order of business this morning is a request by the prosecution to publish Exhibit P-TR-1076, which was admitted yesterday. Without objection, I have granted the request, and without objection by the defense, what we're going to do is distribute copies to all of you so that you don't have to pass one single copy around from one to the other. We think that this will make it more efficient. Please understand, however, that after I give you a moment to review the exhibit, we will retrieve it from you. And so don't make any notes or markings on it. We're just giving each of you a copy right now to expedite the publication of the exhibit. Does everyone understand that? Yes. Great. All right, Mr. Edson, are you ready to proceed?
Your Honor, is there any way we could call some witnesses first and then ask to publish those exhibits?
Oh, all right.
We
Sure.
apologize. We should have clarified that with the court.
Yes, that would have been nice. Okay, you may call your witness.
Thank you, Lucas Smith.
Good morning, sir. Could I have you raise your right hand for me so that I can administer an oath? Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Please be seated. Could you please tell us your full name and please spell your first, middle, and last names?
Lucas Jordan Smith, LucasJordansmith.
All right, you may proceed.
Thank you. Mr. Smith, I'm going to ask you to move that microphone a lot closer to you. Thank you very much. Were you at the Century 16 movie theater on July 19th of 2012 in Aurora, Colorado?
Yes.
Did that go into the early morning hours of July 20th of 2012?
Yes.
Please tell the jury a little bit about what you remember about the day of July 19th prior to going to the movie theater.
Just hanging out at my apartment and, going about my evening.
How did you decide to go to the movie theater that day?
Just wanted to go see the movie and went.
Who'd you go with?
My wife.
What time did you get to the movie theater that night?
I think probably right at midnight, somewhere around there.
What do you recall doing when you got to the movie theater?
Finding a seat, sitting down, waiting for the movie to start.
Right, Your Honor, with the court's permission, I'd like to approach Mr. Smith with what's been marked as People's Exhibit 1225.
Okay.
Do you recognize this diagram, Mr. Smith?
Yes.
Does that fairly and accurately represent where you and your wife were seated the night of July 20th of 2012?
Yes.
Your Honor, at this time I would move for the admission of People's Exhibit 1225.
Any objection?
No objection.
Without objection, P-TR-1225 is admitted.
Thank you. And Your Honor, with the court's permission, I would ask that Mr. Smith be able to approach the model with me to describe what he saw for the jury that night in the theater.
Yes.
Your Honor, may we approach on that first?
Yeah.
Thank you.
All right, the objection is overruled. Sir, you may step down and go to the model.
I'm going to ask that you grab that cordless microphone that's up there too, Mr. Smith, before you come down. Thanks. All right, I'm going to ask if you can kind of stay back here so we don't block the jury's view. Could you please show the jury where you took your seats that evening approximately?
Right here.
And was that the seat where you were seated?
I think I was here.
And where was your wife?
I think right here.
All right. Now please tell the jury what you remember happening when your movie started.
When the movie started, or
What you
when-
remember happening during the movie
Okay.
that evening.
An individual came through this door over here.
And if the record can reflect that the witness is pointing to the exit door close to the far right side if you're facing a screen.
Right. And appeared to be in full tactical gear, gas mask, and through what I believe was an incendiary device.
Objection to the characterization.
You can continue, Mr. Smith.
And through an incendiary device, I think over to here, this area.
And if the record can reflect that Mr. Smith is pointing to the left stairs if you're facing a screen close to where he was seated about 4 rows up from the stadium seating.
Right, and then began shooting people in the crowd. So, yeah.
What did you do as a result?
I got up to leave, and I believe that's when I was shot, and then I hid the rest of the time.
Could you show the jury where it was that you got up to leave from?
Here. I was on the ground here, I believe, hiding, and then, got up from there, ran out.
All right. Could you show the jury where it was that you were hiding and tell them about how you were positioned and how your wife was positioned?
We were just hiding behind these seats right here, crouched down, laying on our knees, if you will, facing this way, just in, behind these seats right here.
What could you hear in the theater during that time?
Gunfire, screaming, people moving around.
What were you thinking during that time?
I was thinking I was going to die, and on how to escape, really trying to come up with a plan to escape. And
Could you smell anything in the theater at that point in time?
You could smell, I believe, whatever was in the incendiary device, whatever that smoke was, or whatever it was, and then gunpowder and, yeah.
All right. Tell the jury about how it was that you got out of the theater that night.
The sound of gunfire stopped, and so I took that opportunity to stand up and grab my wife and run out.
Could you please show the jury how it was that you exited the theater?
Sure. So we were laying here, got up, ran this way, down the stairs, and then out this way.
Did you ever see the shooter again in the theater?
Mm-mm.
Did you ever see any additional flashes?
Additional flashes? After that point, or no? No.
All right. Thank you very much. You can take your seat, Mr. Smith. When you left the theater, did you have an opportunity to realize you'd been injured?
Yeah. So, I guess when I was running out almost to my car, I felt pain in my leg, I guess, and then got in the car to drive away, and that's when I saw the wounds and knew I was shot.
Did you go to a hospital?
Yeah, we drove to Children's Hospital.
Please tell the jury about the injuries you sustained on July 20th of 2012.
8 buckshot pellets to the right leg.
Can you tell the jury about where exactly on your body those 8 pellets were?
My thigh, my right thigh, mainly from the knee to the hip, basically.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 2569 and 4636.
Yes.
Mr. Smith, do those pictures fairly and accurately represent the injuries you sustained on July 20th of 2012?
Yes.
Your Honor, at this time I would move for the admission of People's Exhibits 2569 and 4636 and ask that they be published.
Any objection?
No objection to 2569, objection to 4636, 403, and 401.
Can I see those pictures, please, sir? Thank you. I don't believe P-TR-4636 was the subject of amended order D98B. However, it is relevant. It depicts the injury, and it is admissible under Rule 403 because the probative value of the evidence is not substantially outweighed by any of the concerns listed in the rules. So, Exhibit P-TR-4636 is admitted over objection and may be published. Here you go, sir.
Thank you, Your Honor. If I could please have 2569. Mr. Smith, this is a picture of you in the hospital on July 20th of 2012.
Yes.
If I could please have 4636. This is a photograph of the wounds you sustained on July 20th of 2012.
Yes.
Thank you very much. I don't have any other questions for this witness.
Any cross-examination?
No.
And the jury does not appear to have any questions. May this witness be released from his subpoena?
Please, Your Honor.
Is there any objection?
No objection.
All right, sir, thank you.
Thank you. Have a safe trip.
Ms. Tish McGuire?
Michael White, Jr., please, Your Honor.
Good morning, sir. Could I have you raise your right hand for me so that I can administer an oath? Do you solemnly swear or affirm on a penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, please be seated. Could you please tell us your full name for the record and spell your first, middle, and last names?
Name is Michael Torian White. Michael, M-I-C-H-A-E-L. Torian, T-O-R-R-I-A-N. White, W-H-I-T-E.
All right, Ms. Tish McGuire, you may proceed.
Good morning.
Morning.
Were you at the Century 16 movie theater on July 19th of 2012 in Aurora, Colorado?
Yes, I was.
Did that go into the early morning of July 20th of 2012?
Yes, it did.
Please tell the jury about who you went to the movie with that night.
I was with my dad, Michael White Sr., his girlfriend, Michelle Reese, call her Reese, last name. Also my stepsister, Paula Adams. I was with my girlfriend, Farah Sadani, and her friends from Red Robin.
Did you sustain injuries as a result of being in the theater on July 20th of 2012?
Yes, I did.
Could you please tell the jury about the injuries that you sustained?
Yes, I took a shotgun shell to the shoulder. It went in, it shattered my scapula, broke a few ribs, and collapsed my lung. And also got a bullet in my leg, my left calf.
Did you have surgeries as a result of those injuries?
Yes, I did.
Please tell the jury what happened in your surgeries.
They actually had to remove part of my scapula.
Your Honor, if I may approach the witnesses, what's been marked as People's Exhibits 1178, 2562, and 2563.
Yes.
Do you recognize that diagram, Mr. White?
Yes, I do.
Does that fairly and accurately represent what you recall from the night of July 20th of 2012 in the theater?
Yes.
Your Honor, at this time I would move for the admission of People's Exhibit 1178 and ask that it be published.
Is there any objection?
I have no objection to any of the exhibits, Your Honor.
All right. Ms. McGuire, are you moving the admission of all the exhibits?
I am, Your Honor.
All right. All three are admitted without objection, and all three may be published.
Thank you. If I could please have 1178. Right, if you could zoom into that area for me. So, Mr. White, where it says M Junior, is that where you were seated that evening?
Yes.
Theater? And where it says F, was that where Miss Sudani was seated
Yes.
next to you? And does that recall where you saw some flashes and a canister that was thrown through the theater?
Yes, it does.
All right, thank you very much. If I could please have 2562. Mr. White, was this you in the hospital on July 20th of 2012?
Yes.
Could I please have 2563? Mr. White, there's this picture of your injuries from July 20th of 2012.
Yes, it is.
And could you please tell the jury what a scapula is in case people aren't familiar?
It's actually the part, pretty much the shoulder blade, connects in the back here.
And you eventually had to have that completely removed from your body.
About half of it, yes.
I have no further questions for this witness. Thank you, Your Honor.
All right. Mr. King, do you have any cross-examination?
I do not, thank you.
All right. And the jury does not appear to have any questions for this witness. May he be released from his subpoena?
Please, Your Honor.
Without objection.
Sir, thank you.
Thank you.
Mr. Edson?
At this time, we would request publication of 1076, Your Honor.
All right, folks, we're going to go ahead and publish P-TR-1076. And so, as I mentioned before, we'll give each of you a copy to review, and I'll give you a little time to review it. And then we will retrieve all the copies after you've had an opportunity to review it. All right, folks, I'll give you a couple more minutes and then we'll retrieve those copies from you. Would council please approach while we're waiting? Let's have Mr. Brockler and Mr. King, sorry. All right, the record should reflect that we just finished publishing Exhibit P-TR- was it 1276?
1076.
1076, thank you. All right, Mr. Edson?
Judge, if people would call next Tony Evans.
Good morning, sir. Could I have you raise your right hand for me so that I can administer an oath? You solemnly swear or affirm on a penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
Please be seated. Could you please tell us your full name for the record and spell your first, middle, and last names?
Tony Russell Evans, Tonyevans.
And how do you spell your middle name?
Russell.
Thank you. Mr. Edson, you may proceed.
Thank you, Your Honor. Sir, I'm going to direct your attention to July of 2012. How were you employed in July of 2012?
I was the owner of CannonFuse.com.
What is CannonFuse.com?
CannonFuse.com is a website for amateur pyrotechnic enthusiasts to purchase supplies for making homemade fireworks.
What are some of the types of supplies that can be purchased on CannonFuse.com?
Cardboard tubes, paper plugs, plastic hemispheres, paper shells, mortar tubes, fuse.
In late July 2012, specifically July 20th and 26th of July 2012, were you contacted by law enforcement relating to the events at the theater in Aurora, Colorado, and specifically to an order placed by James Holmes?
Yes, I was.
Did you provide documents to law enforcement to that end?
Yes, I did.
Your Honor, may I approach the witness, please?
You may.
Thank you.
I've handed you what's been previously marked as People's Exhibit 367. Do you recognize that exhibit?
Yes, I do.
Fair to say there are two documents associated with that exhibit?
Yes.
Can I have you just briefly review both documents and tell me when you've had an opportunity to do so?
I have.
What in general are those documents?
The first one is an order invoice and packing slip, and the second one is a credit card merchant receipt.
Are both of those documents associated with records from CannonFuse.com?
Yes.
Are both of those documents associated with a particular customer?
Yes.
Who is that customer?
James Holmes.
Do both of those documents associate with a particular date of transaction?
Yes.
What is that date?
July 3rd, 2012.
As the owner of CannonFuse.com in July of 2012, were you also the custodian of records of CannonFuse.com?
Yes.
These particular documents, do you recognize them as computerized records for transactions associated with CannonFuse.com?
Yes.
Being an online retailer, are your records and invoices, are they all computerized and digitized?
Yes.
The computer records that are before you in People's Exhibit 367, the entries that are associated with making those records, are they done so in the ordinary and regular course of business of CannonFuse.com?
Yes.
Those participating in making the records of that exhibit, are they acting within the routine course of business for CannonFuse.com?
Yes.
Are you familiar with the input procedures and the maintaining of those particular types of computer records?
Yes.
The input procedures associated with People's Exhibit 367, are they accurate?
Yes.
The entries that are associated with People's Exhibit 367, are they made within a reasonable time after the transaction occurs?
Yes.
Can you explain for us what you mean by that, please?
These documents are immediately generated when the customer places an order on the website and when they type their credit card number in.
The information contained within People's Exhibit 367, has it been transmitted by an individual with knowledge of the sales reported, such as yourself?
Yes.
The information contained within People's Exhibit 367, is it kept and maintained in the regular and ordinary course of business practice for CanonFuse.com?
Yes.
Those records, People's Exhibit 367, do you regularly receive, maintain, and rely on those types of records in the normal business practices of CanonFuse.com?
Yes.
Can you just describe briefly for the jury how an order is taken online and processed by CanonFuse.com, please?
Yes, I can. A customer would go to the website, place all the things they wanted in their shopping cart, go through the checkout process, enter in their credit card number. I would then receive the order, print out an invoice, package the order, and ship the order.
To the best of your knowledge and your review of these documents, is that what occurred with these records of People's Exhibit 367?
Yes.
When a customer comes on your website and places an order, is a business relationship established between yourself and that customer?
Yes.
When that business relationship is established, do you substantially rely upon the information provided by the customer related to those orders?
Yes.
The information that you rely upon in placing the order, or fulfilling the order, I should say, is that information contained within People's Exhibit 367 as far as the customer information and the requested items?
Yes.
That information that the customer inputs for the orders, is that substantially relied upon by CanonFuse for a business purpose?
Yes.
And is in fact that the information that is used to ultimately fulfill the order?
Yes.
I'm going to direct your attention to the second page of that exhibit. Are you familiar with a company called Authorized.net?
Yes.
What is that company?
That is a credit card processing company.
Was Authorized.net used in the normal and ordinary business practice of CanonFuse.com back in July of 2012?
Yes.
Explain, please.
That is the merchant service that we use to process all credit card transactions.
As part of the normal credit card transactions where you use Authorized.net, would you receive records from Authorized.net?
Yes.
Did you keep those records in the ordinary course of business for CanonFuse.com?
Yes.
Did you maintain and rely upon them upon your receipt of those documents for Authorized.net?
Yes.
Did you do so in this transaction that's associated with People's Exhibit 367?
Yes.
Did you also in other transactions as well? In other words, was it unique to this particular transaction?
No, I do this all the time.
And overall, noting that the first page is an invoice and the second page is one Authorized.net created, do you keep both of those documents as computerized records for your customer information, invoices, and transactions?
Yes.
And is all of that information contained in the regular, ordinary course of your business purpose, your business practice from CanonFuse.com?
Yes.
Your Honor, at this time, I would move for admission of People's Exhibit 367.
Any objection?
No, sir.
Without objection, P-TR-367 is admitted and may be published.
Can I have the first page, please? A couple of things here, sir. You have the actual exhibit in front of you, and you can refer to that. I think you have it on your computer screen as well.
Yes.
So we have it on the screen here. It's a little difficult to read, so I'm going to have you read some certain parts for us. The top left corner, CanonFuse.com, I'm guessing that's your business contact information from 2012?
Yes.
Ship to, describe what we're looking at there, please.
That is James Holmes' address as given to me by James Holmes.
The invoice number, is that a unique invoice for this particular transaction?
Yes.
Shipped via, what are we looking at there?
Parcel post,
What was the order date of this invoice?
July 3rd, 2012.
Is that the date that the customer, in this case James Holmes, would have requested the items online?
Yes.
If we could scroll down briefly, please, to the items purchased. So I don't need you to go into great detail, but some of this is a little difficult for us to understand that do not have specific knowledge of this. What exactly was ordered and fulfilled in this order?
These would be supplies for
amateur pyrotechnics, including remote igniters for setting off fireworks via remote control, round plastic hemispheres for making mortars, fuse.
So
That's about it.
let me ask a couple questions. The second line there says Saturn, I think it says Saturn missile tubes, is that correct?
Yes.
What is that?
They are just small plastic tubes used for making bottle rockets.
The plastic ball shells, I think it says 6-inch, is that correct?
Yes.
How many of those items were ordered?
11 quantities. So there would be, I think, a total of 24.
Moving to, I guess, the second area there where it says fuse premium, do you see what I'm talking about?
Yes.
Describe the fuse for us, please.
That would be a 1/4-inch time fuse used for timing aerial shells,
What do you
such as a
mean?
ball shell.
Okay, what do you mean by timing? What does that refer to?
The fuse burns for a length of time and then ignites whatever you want it to ignite.
Below that, is that more plastic shells that you're referring to?
Yes.
Are those different diameters, different sizes?
Yes, those are 3-inch.
How many were ordered?
A quantity of 6, and those are coming a dozen to a quantity, so.
Below that, to the third section of some of the items ordered, I see a falling leaf fuse. What does that refer to?
That is a a fuse that burns blue in color, cut into short pieces.
The additional launch control receiver, what exactly is that item?
That would be used for setting off fireworks by remote control. It would work with a launch control firing kit.
Below that, I see an expedited shipping option. Is that correct?
Yes.
If we could scroll down to the bottom here. What was the grand total of this purchase?
With shipping, $183.97.
And I see some initials there. Do you recognize those initials?
Yes,
Whose are those?
those are mine.
If we could go to the second page of People's Exhibit 367, please. In general, what are we looking at here?
This would be the automated response from my merchant account for processing the credit card.
If we could scroll down, please. Under the order information, can you tell us the payment method?
MasterCard.
We could scroll down a bit more, please. Fair to say under customer billing information, that's the billing and shipping address that was requested?
Yes,
And that was for James Holmes?
yes.
It's tough to see here, but can you read off the email associated with customer billing information?
dsherlockb@hotmail.com.
To the best of your knowledge in viewing the records associated with this order, was this order successfully fulfilled?
Yes.
Your Honor, may I have one moment, please?
You may.
Nothing additional, thank you.
Is there any cross-examination, Ms. Brady?
No, thank you.
All right, and the jury may have a question for you, sir, so give us a moment, please. Thank you. Would counsel please approach? Sir, the jury has submitted a question that, based on the rules of evidence and other applicable rules of law, I have determined is appropriate. The question is, can you explain how a launch controller works with fireworks? For example, distance. If you know. You
Yes.
cannot speculate, but if you know, you can answer the question.
A launch controller is a very entry-level method of remotely setting off fireworks. They use Eclipse. It's just a small battery-powered transmitter that works by line of sight with a remote control. It has a very short range, probably 25 or 30 feet.
Are there any follow-up questions, Mr. Edson? Yes.
Just one question, Judge. Could you describe the size of that item?
It's the size of a pack of cigarettes about. The wires are probably 5 feet long, and it just heats up a wire that you would have a fuse connected to, and when you push the button, it would heat up a wire that would light a fuse.
Okay. No further questions, Judge. Thank you.
All right, Ms. Brady, do you have any follow-up questions?
Yes, please. Sir, when you say line of sight, what do you mean by that?
It's not a radio transmitter that would work through walls or around corners. You have to see the receiver for it to work.
Is it kind of like a TV remote where you have to aim it at the TV
Pretty
for
much,
it to
yeah.
work? So if you were in a different room, it wouldn't work?
Probably not. Not with this very entry-level system. You might get lucky and it might go around a corner, but reliably, no.
And what did you say, 20 to 30 feet?
About that.
So beyond that, it probably wouldn't work.
You might get lucky, but it wouldn't work reliably at long range.
Thank you, sir.
May this witness be released from his subpoena, Mr. Edson?
Yes, Your Honor. Thank you.
Is there any objection, Ms. Brady?
No, sir, thank you.
All right, sir, thank you. Members of the jury, it's 5 after 10. Let's go ahead and take our morning break at this time. Let's take 20 minutes. Please make sure that you follow all my advisements during the break. I'll see you back here in 20. Thank you. Everyone may be seated. The record should reflect that the jury has exited the courtroom. Is there anything we need to talk about at this time on behalf of the people? Anything on behalf of the defense?
No, Your Honor.
One other instruction that I thought about, Mr. Brockler, for Dr. Reed would be to indicate to him that if he is asked a question that he's not sure he can answer without violating a court order, that he should err on the side of caution and then later communicate to you or to someone that he wasn't sure he could answer the question without violating the court order. Or he could just say on the stand, I'm not sure I can answer that question based on the court's orders. And then we could take it up outside the presence of the jury. Okay?
Yes, sir.
All right. Enjoy the break. I'll see you back here in about 18 minutes. Thank you. The court will be in recess.
Please rise.